I'm Judge Cheryl Allen. I served as a judge in the Pennsylvania court system for 25 years. I spent 17 of those years in the Court of Common Pleas of Allegheny County as a trial judge. I've served in juvenile court as well as criminal court, where I became very familiar with the Crimes Code. I've also served on the appellate court, the Superior Court of Pennsylvania, where 65% of our cases were from the criminal courts around the state. So I am very familiar with criminal law and how the system works. Now, having examined House Bill 1024, House Bill 1025, 1026, and 1027, I can assure you that this is some of the most dangerous legislation that I have ever seen, because it offers an unbelievable opportunity to completely cancel people and to weaponize the criminal court system to literally ruin a person's life. It will have a chilling effect on other people when individuals are prosecuted both civilly and criminally using these statutes. An example would be, let's say, a parent who attends a school board meeting, and that parent is very concerned about sexually explicit books in the school libraries. And when that parent starts to give an example of those books and the contents of those books, and a school board member tries to stop that parent, and when the parent continues to exercise his or her First Amendment right to be heard and to express concerns about the education that their child is receiving, they are told to leave. If they refuse to leave because they have a legal right to be at a school board meeting as tax-paying citizens, if they're told to leave and they refuse to leave, they can be charged with criminal trespass, which is a first-degree misdemeanor under our criminal statutes. And if they are deemed to have refused to leave, and their language and their actions can be deemed as hate-motivated intimidation, they could be, upon conviction, upgraded. That charge could be upgraded to a third-degree felony, which carries a maximum period of incarceration of 3.5 to 7 years. Now, regardless of whether that person receives a probationary sentence or a jail sentence, prison sentence, upon completion of, as a condition of their probation or as a condition of their parole, they would be required to undergo 8 hours of education, which I characterize and believe is sensitivity training. They would also be required to undergo 8 hours of community service to the offended community. And one can just imagine the opportunity for abuse that person might have to undergo, because if they fail to successfully complete the community service and the education, they can be deemed to be in violation of their probation or their parole, which could mean that they are further sentenced to a period of incarceration or punishment for the probation violation. And if they should, by any chance, be charged with another hate crime or another example of hate speech, their parole or their probation for the first charge could be revoked, and they could be required to finish out their sentence, and they could face a new sentence, which is definitely going to be more harsh than the first sentence, because they would be considered a repeat offender. And so this is how people get into the criminal justice system and never leave the criminal justice system, because they're constantly charged with probation violations or parole violations. Also, a person who is convicted of a hate crime is highly unlikely to ever be able to receive employment, taking care of children in any school or university. They're highly unlikely to be able to get a job in the healthcare profession or in any position which is going to require interaction with the public. Or, There are many employers who just don't want people on their in their employ who have criminal record. And so this person is going to be stuck with that criminal record for life and probably never going to be able to expunge the criminal record. And that's how that person would be completely canceled, because he or she would be completely unable to fully participate in life. For example, we had a case involving a young boy. I believe he was about 12 years of age, and he wore a t-shirt to school which said, in essence, there are two genders. That was considered to be hate speech, and they insisted that he remove the t-shirt, that he never wear it again. I can envision that if an adult wore such a t-shirt, that adult could be charged, could have an anonymous complaint filed against him by whomever, alleging that he had engaged in hate speech, that he was asked to leave a particular place with that t-shirt, and when he refused to do that, he committed criminal trespass. That, you know, he's basically canceling out people and showing hate toward individuals. Yes, it does allow for ideological prosecutions. I mean, we're living in a time when many district attorneys don't appear to want to prosecute serious crime or violent crime. I mean, actual violent crime. Yet they're willing to say that misgendering someone is an act of violence, or stating that there are only two genders is somehow hate speech, or that somehow you're canceling or denying the existence and the identity and the person who is transgendered, or who is whose sexual orientation you may or may not agree with. It's completely driven by what you believe rather than what you actually do. These are just some of the reasons why I know that these proposed bills are very dangerous, and the opportunity for abuse, for these laws to be weaponized and abused for people who simply may express a different viewpoint, is just endless. The opportunity for lives to be ruined, innocent people with no criminal record will suddenly find themselves with felony charges or any record. They will be completely canceled.